So there is this growing trend on TikTok with people giving legal advice. Now, I generally don't recommend you take legal counsel from people on TikTok. So what kind of advice is out there? Well, you're about to find out. I'm Joshua Roberts, attorney at law, and you are watching Lawyer Up. In today's episode, we are going to be looking at legal advice that various people are giving on TikTok. We're going to look at the video, and then I'm going to talk about what's right about it, and then we're going to talk about what's wrong about it. And ultimately, I'll give it a thumbs up or a thumbs down. Now, remember to comment, like, subscribe, and share me on social media. And also, we are available on all podcast outlets. So without further ado, let's get to the TikToks.
Pulled over by the cops, do this.
Acknowledge the officer by turning on your flashers.
That makes some
Safely and
sense.
calmly pull over. Turn off the engine.
Yes.
Roll down both your windows.
Let the officer speak first. If he asks you why you were pulled over, say, "I don't know, officer."
Pull out your documents.
Oh, I
if
just
they're
make stuff
readily
up?
available. Bonus tip, don't consent to a search.
Okay, interesting. Now, the first part of this video is good. You want to, when you're being pulled over, pull to a safe location. You want to shut your vehicle off, roll down the windows. Then it's important to pay attention to the officer. If he or she is still in her car, then you can get your license and registration out. But if they are approaching your vehicle, I tell my clients, you better make sure your hands are visible. Put them at 10 and 2 on the wheel. As the officer approaches, don't be digging through your console or your glove box because that makes officers nervous, right? I even tell some of my felony clients who the officers are going to know they're a little rougher around the edges based upon the license plate and their license history. I tell them to roll down the window and stick both their hands out the window so the officer can clearly see your hands and they know that no funny business is going on. Now, the next thing that happened was the officer asked the individual why they were pulled over. And I know a lot of different officers, have worked with them over the years, and they have all told me that if you're honest with them, that you stand a much greater chance of getting out of the ticket. So why you would just say, "I don't know," if that's not the truth, is beyond me. If you were going a little fast, say, "Yeah, officer, I'm sorry. I didn't know what the speed limit was, and I was going a little over the speed limit. Apologize for that." If you're honest with the officer, you stand a better chance of getting out of the ticket right there on the side of the road. Also, the last thing that was said was don't give permission to search your vehicle. Now, this obviously opens up a huge discussion that we don't have time to go into today. But the answer to that question is obviously it depends on the circumstances. It's a complicated topic, and I would invite you guys to look at one of my videos called the Warrant Requirement that goes into detail about all of these types of searches. But I tell people if you've got nothing to hide, then tell the officer to search away. Often, if you give consent to a search, they won't even look through your car unless they have a reasonable suspicion or probable cause that something is afoot. Now, if you have contraband in your vehicle or a weapon or something you're not supposed to have, then you could generally will want to deny consenting to the search. Now, that doesn't mean you're going to get out of it because they may bring in a drug dog to sniff around your car or they may get a warrant to search your vehicle, but at least you've put the most blockade in the way that you can to protect your rights as a citizen. So let's move on to the next TikTok.
How to get a speeding ticket removed from your record or drop down to non-moving violation. First, show up to court. See if the officer showed up. If the officer is
You need
there,
to show up for court.
ask for the speeding violation to be dropped down to non-moving. If the officer's not there, proceed to trial and plead not guilty.
No, that doesn't
The
make a
case
lot
will
of sense.
likely be dismissed. Worst case scenario, ask the prosecutor to enter pretrial intervention. At the completion of your course, it should dismiss the ticket, and your insurance will not go up.
Okay, there's some goofy advice in that particular TikTok. So the first thing he said was go to court and see if the officer is there. Nope, that's not what you do. The officers are never going to appear at a first appearance. The first court date that you get on the ticket, that's called an arraignment. That's where you show up and you either enter a plea of guilty or not guilty. It's not an evidentiary hearing, so there's no time for testimony anyway. Generally, on the dockets that I see, they'll have 75, 100 people all set for 9 a.m., and they're just there for a very, very quick entry of appearance, and basically they show up and they enter a plea of not guilty, or they sometimes will, on a traffic ticket, plead guilty. But the officers are never there because it's not set for trial. So if it is set for trial, you want to plead not guilty and you want to have your day in court, that trial will be set down the road. It's not the same day. It allows the prosecution to subpoena witnesses, including the officer, and it allows you to subpoena witnesses as well if there are any that are relevant to the ticket that you're charged with. So if the cop doesn't show up at trial, then you may be in business because that is the evidentiary hearing. But most of the time, they do appear. Now, what you can do when you're at your first appearance is ask to talk to the prosecuting attorney. Generally, they will offer some sort of a plea agreement, and if you can get a resolution where that ticket will go away or be off your record or be a non-point violation like defective equipment, then you're good to go. You can enter that particular plea on that date. Otherwise, if the prosecutor's not willing to work with you, then it's time to hire an attorney and to lawyer up. So in regard to this TikTok, thumbs down again. Bad legal advice.
I sued a 9-year-old kid and won. Now, before you jump all over me, let me quickly tell you about the case. I represented a woman who was driving. The 9-year-old kid rode his bicycle out into the road. My client avoided hitting the kid, but in doing so, she rolled her vehicle 3 times and sustained serious injuries. I knew that the kid probably lived with parents that had homeowners insurance and that the homeowners insurance would cover his damages. So what did I do? I filed suit, and I had to prove that the child deviated from what a reasonably prudent 9-year-old with the similar experience and intelligence would have done under the circumstances. I sued a 9-year-old and won.
So, sued a 9-year-old and seems to be bragging about it, right? That's not something normally men will brag about. Hey, I took candy from a baby. I beat up a 9-year-old. So, the video does have a little bit of a douchebag vibe to it, right? But what he says makes a little bit of sense. Now, obviously the 9-year-old wasn't actually the defendant in the case. They usually will have a guardian ad litem appointed, but the legal theory behind all this, that 9-year-old wasn't insured under the family's homeowner's policy of insurance that had been taken out by the parents. And your homeowner's insurance generally covers accidents and things that happen in and around the home. Now, the policy would have to be construed kind of liberally to cover this type of an incident. Probably what happened was the kid rode out of the driveway of the home into the street, causing the rollover accident. And if that's true, then the standard is whether the child was negligent in acting like a reasonable 9-year-old in this case would act under the same or similar circumstances. It's not what an adult would do, it's what a kid of the same age would do. In this particular case, he says he won, so presumably some money was paid out. And it wasn't paid out by the 9-year-old. They didn't go in the house and bust his piggy bank and take his quarters, right? It was paid out under the parents' homeowners insurance company's policy, under which the 9-year-old would have been an insured. So the money that was had would have come from the insurance company. So the legal advice given in this TikTok, or the legal information, I give it a thumbs up. The way it was delivered, kind of douchebag style, thumbs down on that.
Hey, here's a little video for my Generation Xers. Since we all love muscle cars and hot rods and probably get tickets from time to time.
We do.
I know I do. Here's how to get out of a ticket legally. So let's say you get a ticket. You ask for a hearing. And on the morning of your hearing, you call the courts and you ask them how much it is to pay the ticket off. And you get a money order for more than the amount that the ticket's worth, and you send it in.
Just seems like
and
it's
then
going
they
south.
have to get a money order to pay you the difference. And then you never cash it. And the case is never closed. It's never completed. And it never goes on your record. Ever. And that's 100% legal. You're welcome. Follow me.
Okay, wow. So how to get out of a ticket from this guy? Well, that is one of the dumbest things I've ever heard as far as how to fool the system or the computer system to get yourself out of a ticket. He says you just get a money order for more than the amount that you actually owe. And then when they refund you the money, you just don't cash that check or that money order. So in order to pay the ticket, you have to enter a plea of guilty, right? You can't just show up and say, I'm not guilty, here's some money. That's not how courts work. It's the plea of guilty that puts the ticket on your record, not whether you satisfy the ultimate sentence or the fine or the cost after the fact, right? Some cases will drag on after the date that you're in court because you got to pay fines, you got to pay court costs, you may have to go to driving school or something else. And whether you do those things or don't do those things is not the primary factor in whether that ticket winds up on your record. It's the plea that you entered and whatever plea agreement that you entered. So this is not at all good legal advice. In fact, if you follow this person's advice, you have pled guilty to the ticket, not an amended charge, but the actual charge, and you've paid more money than you actually owed to the court. So advice like that gets a double thumbs down.
Okay, so I keep seeing this post going around social media where it's like, well, no one can stop us from drunk dialing our senators, which is hilarious. And then it's got like Mitch McConnell's number on the bottom. But like, okay, can I just like call my senators with like a kid voice? Could I be like,
Mr. Mitch McConnell, why did you let 200,000 people die? I don't understand.
Like, that's awesome.
Is that allowed? Am I gonna get in trouble for that? Someone with like a law degree or something, tell me if I'm gonna get in trouble.
I will. What a weird question. Can you prank your congressman? Well, of course you can, right? It's a free country. You can call up your congressman and say, whatever you want within reason, right? You can't threaten them. You can't verbally assault them. Can you talk in a kid's voice? Yeah, you can do that. Now, if they tell you not to call back, then you probably ought to listen because there are charges for telephone harassment. You usually see it in the domestic context where somebody calls their significant other over and over and over. You can be charged criminally with telephone harassment. You can also be charged with telephonic stalking. It's a new crime that's out there when you repeatedly call somebody. So if they tell you don't call them again, then don't call them again. But you can always call up Joe Biden's office once and try to make an appointment for Mike Hunt, right? So this video didn't provide any advice, but it's a good question. I'm gonna give her a thumbs up. Uh-oh. Oh, I like this already.
The Trunk Monkey Theft Retrieval System. Because sometimes getting your car back
Get a monkey.
is simply not enough.
Drag him out. That's
Another
service.
revolutionary idea you'll only find at Suburban Auto Group, pending approval by Department of Agriculture.
So, trunk monkey security systems, right? Now, if we get away from the concept of leaving a live animal in your car with the windows rolled up, right? If we just forget about that, the trunk monkey as a security measure would be legal. Now, you can't use deadly force in defense of personal property, right? So if there's no human in the car, you can't use deadly force to protect the car itself. You have to use reasonable force. Deadly force is only allowed in situations where you're protecting human life. So if the car isn't occupied, like I said, then say shotgun monkey would not be appropriate. But a monkey that bonks somebody over the head, that is reasonable force and would be perfectly allowable in defense of your automobile. So I'm gonna give trunk monkey 2 thumbs up.
If you trip over a sidewalk with yellow paint, that means the property owner knew that the sidewalk was dangerous but was too lazy to fix it, and you probably have a case.
Okay, the yellow paint on the sidewalk in disrepair. So what the TikToker says is that if there's yellow paint, then that proves that the owner knew about the problem and you probably have a case. The biggest problem with his line of legal thought is the defense of an open and obvious danger. If a reasonable person would have observed a particular danger and avoided it, then there is no recovery. And when you put yellow paint on something, you're making it more open and obvious. Now, the concept is something like this. I own a stove and I turn it on and I put my hand right down on the burner and I burn myself severely, right? and then I say, well, I want to sue you, stove company. I want to sue you, Whirlpool or KitchenAid or whoever it is, because your product severely burned my hand. And it did. That's the product that burned my hand. However, there is a defense if the particular danger is open and obvious, like a hot stove would be. It's the concept that you can't sue a knife company because its knife was sharp, right? It's like, well, yeah, that's what we do. So if the danger is open and obvious, there is no recovery for the plaintiff. And when you take a broken sidewalk and you put bright yellow on it, you are making that much more open and much more obvious than it was before without the paint. So may you have a lawsuit? Yeah, maybe, but probably not. So for that bit of legal advice, I'm going to give him a thumbs down. So that's the episode. We tried something a little bit different. Let me know if you liked it. If you guys enjoyed that, we will do some more TikTok legal reviews. If you run across something that's goofy you want me to take a look at, then send a link. Put it in the comments below. We'll take a look at the video, and we'll do this more often if you guys enjoy this type of entertainment. So that's a wrap. Hope you've enjoyed it. My name is Joshua Roberts, attorney at law, and you've been watching Lawyer Up.
Send lawyers, guns, and money. Dad, get me out of this.